Good morning, everyone. Can everyone hear me? Okay, thank you. Okay,
Yeah.
so let me just call very quickly. I won't hold you all very long this morning. And thank you very much for holding for the court. Let me see. So I'm going to call the matter 24CH 6466. This is the matter of the state of Georgia versus John Carson Bryant. That is the state of Georgia with John Carson Bryant versus Jamal Bryant and Latoya Odom. The reason why I call this hearing, and actually it's more of a status or because the court became aware that this proceeding was shared hundreds or actually probably thousands of times via YouTube and on other various social media platforms, sites, things of that nature. Very concerning to the court. We generally have, as you can see now, a no recording warning that is placed on the court's Zoom site or which the court does opens via YouTube, but we normally do that, and I do that for the very purpose of ensuring that no one records. However, it's very difficult to, I guess, to monitor that to make sure that it's not being done. But I just wanted to make certain that everyone on this call was aware that there is a no recording sign, and that sign is posted on each proceeding every single time that the court meets. So it was very alarming to the court that this got out, and it probably affected everybody on the platform. I know Mr. Walker is new, and it wasn't here when the proceedings was initially presented, but I'm certain at this juncture his client is aware that it has hit social media and various different platforms, and of course it is concerning to the court. And so I wanted to first mention a couple of things. One, when we had the hearing, although this was on a child support calendar, and generally for child support calendars, I call them in the morning. I do YouTube primarily because of course, right after the pandemic, we started using these virtual platforms. People wanted us to continue to use them because it allowed them to continue work and basically for convenience. And out of convenience sake, the court continued to have its UISA and its DHS calendars via YouTube to keep everybody working. And so that was one of the reasons that we did that. The other, of course, to comply with Open Courtroom, we did the YouTube platform so we can comply with Open Courtroom. And also the problem became is that when we use just Zoom, it was very difficult for the court to control people bursting out loud, saying things that they shouldn't be saying, participating in the proceedings that they shouldn't be participating in if we use the Zoom platform. So I went to the YouTube platform so people can view it, but not have the ability to comment. And then consequently, the court didn't have to kick people out and cause disruption in the court. So I started using that YouTube platform in that regard. But I do want to mention that on the day that the court had this particular hearing, I also had domestics. It is the court's position that when I have domestic hearings that are involving children, I do not record, I do not have the YouTube platform running. It runs through my courtroom. And so when it runs through my courtroom, I'm complying with Open Courtroom by having the Zoom going through the courtroom, not through YouTube, and consequently, anyone who wants to participate would have to come through the courtroom. On the day this hearing went, we were doing both. It was one of those days we were just doing both. Well, we had YouTube going for DHS matters, USAID matters, and then we had our regular calendar going with regard to our domestics calendars. I could tell the difference because when I look on Zoom, if I can see my courtroom, I know that I'm in the courtroom and that it is not on Zoom. It is not on YouTube because I can see the actual courtroom. So I preface all that to say that when the court had this hearing, it was a comeback hearing. I think I asked you guys to come back at 12:30 that day. And that was connecting into my domestic calendar, the very domestic calendar that I had that day. And I saw myself into the courtroom. So I did believe at the time that when we were having that hearing, that we were actually in the courtroom. We were not. We were on YouTube. And quite frankly, this matter will likely have been on YouTube because it met the YouTube requirements that I normally would place on YouTube when I'm doing just the child support calendars. But I say that to say that this particular case, I did think that I was not on YouTube. I thought that I was in the courtroom. So because I could see the courtroom itself. Regardless, I recognize, and probably for most of you on the Zoom right now, platform now, that might have been very upsetting for the YouTube videos to kind of be exploited in the way that it was. And so to that extent, the court apologizes for that. I have since revised the process. I have decided that with regard to various YouTubes, when I do run them, I'm going to put certain procedures in place and not handle certain matters when I'm doing YouTube, because unfortunately, although it's a convenience for many people, it is being abused, and that is not how the court wanted that. So to the extent that for Ms. Odom and Mr. Bryant, to the extent that caused some despair for you, I do apologize. But it was not the intent of the court. And I do have that recording notice, as you can see right now, always going anytime I have a proceeding. And also for you, Ms. Harris, I'm not sure. I know it just got rampant. So I'm not sure if anybody approached you like they even approached the court about it. That's how I found out about it. I was just going about my regular business. To the extent that it caused you all any discomfort, any stress, I do apologize for that. But that it is the normal process that we basically took on as a result of COVID and kind of lingered for the convenience of many. But as I indicated, I'm going to start doing things very differently now because I dislike that so much. The reason why that I have decided to do this hearing via YouTube, because I wanted to put that out there and I want everybody to be mindful of it, that was wrong. And it was not sanctioned by this court whatsoever. And so that was the first thing. The second thing was that appeared to have caused some concern with regard to Mr. Bryant, was that the court indicated that I was going to, it appeared that the court indicated that I was going to have Mr. Bryant arrested, and I wanted to clarify that. So I don't know if you all had an opportunity, if to the extent that you saw, and you may not have, I probably doubt it, but to the extent that you reviewed the entire recording, then you would probably appreciate what the court is going to say. There was a portion wherein I asked whether Pastor Bryant was on his honeymoon, and I think Ms. Harris indicated that he was not present, but not because he was on his honeymoon, but because he was on a prison mission. And at that point, I indicated, well, he should be here. Isn't that bench warrant status? And it basically kind of got cut and spliced to the extent where it almost appeared that I was issuing a warrant. And I want to make sure that was clear. That was not the position of the court. I did not intend to issue a warrant. In fact, based on the type of proceeding, the court could not do that. But as I started from the beginning, when I recognized that I was thinking I was in the courtroom, I did not retract that statement. I should have, but because I thought I was in my courtroom, I didn't see the need of doing it when I later realized that this was in fact just a modification case. And so, but that got out there as if there was something that Mr. Bryant had done wrong, and that was not the intent of the court. And I did not mean to place that out there in that atmosphere at all. So I want to clear that up. And finally, I wanted to put I'll put on the record that in light of those mishaps, that the things that the court mentioned that were not correct, the fact that the recording got into the atmosphere and caused some distress. The most important thing to this court is making sure that everyone understands that this court wants to ensure that everybody's rights are protected. I want to ensure that everybody feels that they're being heard. But most important, I want to ensure that everybody feels that they're being treated fairly. And I want people to appreciate the court system. I want people to appreciate American jurisprudence. And in doing that, I think it's very important that people have a sense of respect for the court and respect for the process. So I don't want to in any way in my behavior impugn on that, because I think that is very important. So for those reasons, the court is going to recuse itself from these proceedings. I am doing that so that everyone will have the opportunity to start over, and that there would be no repercussions with regard to how people responded to you, or how people might have responded to the court, or even influenced the court by that recording getting out the way it did. And so that's the reason I'm presenting, to let you all know that the court will recuse itself, because I think it's most important thing is that the jurisprudence reflect a sense of fairness, impartiality, and I want to make sure that no one leaves stressed about the way this proceeding started. So that's the reason why I called, to let you know, called the hearing to let you know that that is what the court is going to do. Further, of course, I'm not having any additional YouTube matters that involve people's children. So if children are involved, where we are discussing any, I would say, any matter that is concerning to the court, then the court is not going to have those YouTube hearings any longer. It's unfortunate, because I feel like it helps people stay working, but by the same token, it's being abused. And so the court is going to take a different perspective with regard to that. All right. Anything anyone wishes to say regarding the court's position?
Yes, Your Honor. First of all, thank you for noting that. I'm just coming in on this case, and I have watched the video in its entirety several times, and there were some things that were very, very troubling. So I appreciate you saying what you said and doing what you've done. It has caused my client and his wife great harm at this point. And it's kind of like trying to put spill milk back in the bottle. She is being abused on social media, so is he. And I feel like maybe he's been prejudiced to a point where I'm not sure if we can rehabilitate that. It's causing his earnings to be affected. But we will have to deal with that at a later date, Your Honor. I do have one procedural matter. I was looking at your order, and because the Legee, Miss Odom, signed, she filed her extension late, and it was a whole issue around that. I'm not sure if you were aware that the DA's office gave her erroneous information. And the person who gave her that information where she could file late has now been terminated, to understand that. But in the order, on the second page, the box should be checked. It says that there was that there was no objection to the petition filed by either party within the time allotted. Well, that's not the case. It was an objection filed, but it was filed late by Ms. Odom. And
so let me just stop you. I'm not even sure exactly what you are mentioning about I'm not certain. So you're gonna have to start over.
Harris,
Your Honor, I can speak. And I second his sentiments. Thank you for doing this and for clarifying everything. Excuse my voice. But in the order that I submitted, and I take ownership of the error, and I am pulling it up there is a section where it states, go ahead.
Page 2.
Yes, here it is.
Order.
On page 2, on the top of page 2, and if Your Honor would like for me to share.
I have it. I pulled it
Okay,
up.
okay.
So the temporary
it says,
dismissal order.
yes, Your Honor. And on page 2, where it states, so the first line, there's an X stating that the parties are subject to the jurisdiction and venue of this court. Then there is a second line that says there was no objection to the petition filed by either party within the time allowed. I erroneously did not check that box, and in fact,
Okay, hold on. So I see paragraph 2 dealing with jurisdiction. Okay, so where am I? At the top or below? There was no more, one or more objections, and a de novo hearing was held by the court.
The one right above that.
There was no objection to the petition filed by either party within the time allowed.
Yes, and so I should have actually checked that and probably modified that there was an objection filed. It was untimely, but it was filed, which is what leads us to the next one, that there was an objection filed and a de novo hearing was held by the court. So if the court would like, I could submit an amended order clarifying that issue.
Okay.
And I want to clarify that the case manager, I'm not sure whether or not she's no longer with this office. I can say that.
Okay. So, okay, let me see. So I signed this December 3rd. Okay, to the extent there is an amendment, go ahead and process it.
Okay.
But I don't know, Mr. Walker and Ms. Odom, are your position you want the court to handle that prior to recusal? Because I don't really want to touch the file, because I really don't want, like I said, I don't know about, well, I will do what both of you are in agreement on. That's fine if you are both in agreement on it. But I've just indicated I was going to recuse myself. So I don't know if it's best for me to allow another court to handle even those minor corrections. Let me hear from Ms. Odom. Can you unmute?
Good morning, Your Honor. I do want to just say thank you for that. My son has been bullied even more.
I do apologize.
It's
I mean, and I can imagine the stress that it's cost you. You cost your son, and cost everybody. Like I said, including myself, I was actually harassed at at different places as well, which is very odd for the court.
I didn't even know that it was streaming live. I was like, I'm getting calls. I'm like, I have no idea what y'all talking about. Yeah. But
I do apologize for that.
But I will say this to what they're saying, because it's an interstate case, some things I'm not getting on time. And then when I do ask, I've had, I want to say 2 or 3 different caseworkers, and I have a new one now. She just called me yesterday. So she's trying to get caught up on the case as well. So to that extent,
is this related to this issue?
No, this new one.
What I was asking you about was whether or not you had any objections to the court making the amendment on the temporary order prior to recusal.
Yeah, I do. Yeah.
Okay.
Yeah, I still want my objection in there. Definitely, because I'm
going to let whoever gets the case to make any changes to the order. And I'm actually just seeing, Mr. Walker, looks like you were filing some protective orders and a motion to seal and all of those things. I'm going to let another court make those decisions with regard to the case. I would note that and I just, and also that you'll be aware of this one is Mr. Walker as well, that when the matter came as a modification and the income was presented at the time, I did not recognize that the court had sealed the income in the other case. It was only after I connected the cases that I could see, but by that point, the information was already presented. So, but by the same token, and I don't mean to, like I said, impugn anybody, but because he wasn't present, he wasn't able to let me know that that information should be sealed and it should not be presented in open court. Otherwise, I wouldn't have done it. But I just want you to know I did not see that until when we were in the middle of the hearing. I asked Ms. Harris to put it on the screen. She put it on the screen. Then I was like, okay, I think this is Pastor Harris, Mr. Harris's case. Let me open up the file. Then Ms. Odom noted that the file was supposed to be sealed. The file isn't sealed. I only sealed the financials. So then I realized the financials had been sealed, but by that point, it had already been presented in open court. All right.
And Your Honor, Your Honor, I do want to say that, here in the DA's office, we did know the parties. And so I want to apologize because it was my understanding we can't treat anybody differently. And so, hindsight is 2020. And I understand you probably needed the heads up beforehand, before open court, knowing that this was potentially a high profile case. So I do apologize on our behalf because that's kind of how the bag, got opened. And
well, we had a lot going on. So I think this is the best route, is to just for this court to recuse itself, and everybody can just kind of start over. And hopefully just kind of those issues, another court would be able to take care of it. But at this juncture, I think those motions should be heard by someone else. But the income information that I had on the previous case, that remains sealed. It remains under seal. I just did not seal the entire case. I only sealed portions of the case. And so I'm going to let Mr. Walker take that up. I'll have court admin handle it as swiftly as possible so we can get somebody on it and let that other court take care of it.
I do want to say,
just so that we're all clear as to expectations for the next steps.
Okay.
Since the DA's office, since DCSS, we're kind of driving this case, is it my understanding that we should wait to hear from the court or the court staff regarding next steps about scheduling the motions, hearings, and all that type of thing?
Right, because what I'm going to do when I get off of this call, I'm going to send my recusal to court admin. I'm going to ask court admin to have it sent to another division ASAP. Then I will let that division know that there are some motions to seal, motion for protective orders, and I'll put this in my note that need to be handled immediately. So I'll put that I can't say when we do the recusals like that, we really don't need to go into why I'm doing the recusal. But I will indicate that there are motions outstanding that need to be handled immediately. And then I'll push that to court admin. Court admin will then find another division to handle it. And then that division will know that these are matters that need to be resolved quickly.
I do have something to say. I have retained an attorney, but my first consultation is on the 23rd. So she needs time to review this because what Mr. Walker is asking for, I do want counsel.
Yeah, you can, like I said, yes, you'll have, I imagine because we're going into the holiday, I imagine you'll have a few weeks anyway. Okay. I don't see anybody probably doing anything having any hearings within the next couple of weeks. Maybe they might entertain the motions before then, but having the hearings are probably unlikely anyway. So you should have an opportunity. I would move quickly because you just never know. Because I will put in here that there are 2 outstanding motions that need to be handled quickly. So I'm not sure exactly what that means for the division it might go to. But I will do that. And then next steps would be they'll make contact with you guys, set a hearing, and then all those issues would be handled. And I think at that time, even though some of us are still handling our matters via Zoom and some of us are still handling our matters via YouTube, you might absolutely want to indicate that you want all your proceedings in person. Mr. Walker and Ms. Odom, that is something you all want to mention ASAP to the new judge, to the extent every court will handle it the way they want to. Your motions are what your motions are, and they will make a decision based upon what their process is. But just kind of learning from our missteps, you might want to just make that an issue. Okay.
I have one last thing, if you would, induct. I think because we can all agree there was some missteps in that first hearing, you did issue a temporary order that deviated from ADA Harris's recommended order based upon some information that we can talk about or not, because you're not going to be on the case anymore. I would respectfully ask, Your Honor, before you turn this over, could you go back and just kind of void your temporary order and set that aside until the next court has an opportunity here? Because right now, my client has been prejudiced and he has been made to pay more than what ADA recommended, even despite them recommending an upward deviation. So my client has received an upward deviation from the upward deviation. And
no, so let me make sure you understand, Mr. Walker, what I'm doing. I'm doing this for perception. Procedurally, what I did procedurally was correct. But perception, that is the reason, that is the judicial canon that I'm using. Your client received notice. He was supposed to be in court. He chose not to be. That's his issue. Okay. So the notice, even in the notice, it indicates that I'm going to handle these proceedings generally. And I'm not certain 100% sure on these Zoom notices that I normally turn in, because on mine, it'll also indicate to you that the hearings are going to be held via Zoom. I'm not sure if the notice for these proceedings indicate that. Do you know whether the notice indicate that on yours?
Your Honor, it's on our notices. It does say Zoom, but it does not say YouTube.
Okay. So on my actual website, it indicates that all my Zooms are connected via YouTube, and all my general notices, like the one you got now, it also says that. But because I understand that perhaps, there is the perception of it, that's the reason. But by the same token, whether he was aware that it was going to be on Zoom, or whether he was aware that it was going to be in any other platform, even on Zoom, there are people who can participate in those proceedings. They're just not supposed to record them. But people in the public it's a public platform, so people come in and out, people talk. I just don't like the way that this one was presented to the world. But what I did procedurally was correct. Your client was noticed. Your client knew what the proceedings were going to be about. He had the obligation to come. Just because he agrees on something doesn't mean that the court is going to agree on it. I have to agree on those things, which means that I get to hear it. I get to make the final determination whether I'm going to accept what the parties want to do within the best interest of the children, but I make that decision. And so I'm not sure if he was aware of that. Perhaps he wasn't. But when he is not here, then the court proceeds. And so he was not here. And as you recall, if you watch the video initially, I indicated why I thought he was getting married. He wasn't going to be here because he was on his honeymoon. That would have been okay with the court. I would have understood that. But then Ms. Harris said, no, he's not on a honeymoon. He's on a work trip. And that is what caused the court some concern, because I'm thinking, okay, a regular work trip, everybody on that Zoom call at the time, they're working, and I can't treat him differently as a result of that. So procedurally, what I did was correct, but I understand the perception that how it got out and how other people might accept it. And I don't want him to misunderstand, Ms. Odom and everyone else who's watching the Zoom, to feel as if there was some sort of prejudice placed on him or Ms. Odom as a result of the fact that it got out the way it did. But procedurally, I did what was correct.
Yeah, with all due respect.
But by the same token, I will give you an opportunity you will have the opportunity to go with another judge, and then you can bring up all the issues that you have. And to the extent someone believes that I was incorrect, then you'll have the opportunity to do that. You file your motion for reconsideration within how many days has that been?
The hearing was November 20th.
Huh?
The hearing was November 20th.
November 20th. You got to file your motion reconsideration today, but you have 30 days to file your motion reconsideration. Another judge will just hear it. But my position right now is that he was noticed properly. He understood what was going to be discussed at that time. It was his choice not to be represented by himself or you or another counsel. So
Your Honor, and please forgive me, but I hearing that was kind of why the direction that the court took. I do want to note I probably should not have disclosed, because I don't know. I was not aware, because we try to make sure that we are impartial and that we don't get too personal with either party. We try to present the facts. So whether or not he was I didn't know that he was getting married. All I knew was that he was going to be out of the country. He did indicate that it was for with the church, but if I had known that would have made the difference in regard to how the court would have ruled, I would not have disclosed that situation. But additionally, if I knew that it would have been a problem for the court, then because since we set our own cases, we would have set it at a time in which he was certain that he could appear. He didn't say that he wouldn't, but he was going to try. But I would have set it so that that it was confirmed that he could appear. The reason we moved forward was because Ms. Odom was adamant, and we understood that it had been on the docket, and we wanted to keep the case moving forward. But if I knew that there would be any issues with the court, particularly that, I don't want to say disrespect, but that it would have been problematic, we would have done it at a time in which it was certain that all parties could be present with no issue.
And I appreciate that, Ms. Harris. I really do. And like I said, I'm trying to do what is best for both parties. And I think at this point, I need to recuse. Okay. And so Ms. Odom, obviously, position is that what occurred, I'm assuming she doesn't want me to change it because he was noticed. And I understand that generally the DA's office can, put what's on the calendar, and perhaps the DA's office thought that the court would follow the modification. Sometimes I do, sometimes I don't. And so that's just kind of what it is. And my position is that everybody should be treated the same. And that's the reason why I proceeded, because he was noticed just like everybody else that was on that call. And it didn't make sense for me to treat it differently. So that's why I did it that way. So what I'm saying to you now is I am going to recuse myself to the extent that you want to file for motion for reconsideration because of those particular things that you presented. You can file that, Mr. Walker. You probably need to do it today because you have 30 days to file those motion for reconsideration. Another court would look at it and make a decision if whether or not they wish to do anything differently. But by the same token, it's a temporary order. And so, that's up to you. It's a temporary order. I put it in place until those particulars could be, whatever the particulars were, which I can't remember all of them, could be flushed out. Okay. So it's not done. If I wanted to finalize it, I could have finalized it. I didn't. It's a temporary. All right. And
can I say something, Ron?
Just one
He
last
didn't
question.
even, he hasn't abided by what you.
Your Honor, I need to address that.
I object to that.
We're not. There's nothing to address because I'm done.
But could you? And I don't know if you can or cannot put prior to recusal, but since it's your order, would it be possible for Ms. Odom to be ordered to provide us proof, because we need that as part of our DA's policy, proof of income. We have requested through she and through her state regarding the proof substantiating what she testified to in regard to her income, and we haven't received it yet. So I don't know.
So I would say again, I have taken my position that I am.
No, you're stepping in.
And that is through all matters, but to the extent Ms. Harris, to the extent Ms. Odom, you owe the DA's office some documents so that they can actually prosecute and handle your matter. You need to do it. But as far as any repercussions for that, I'm going to leave that to someone else. Okay. So thank you very much. I guess I took up more time than I anticipated. I thought this was going to be fairly short. I just wanted to indicate that I want everybody to have a full appreciation for the judicial process. I want people to understand that perception is important. And that I don't want that perception to be lingering out there. I wanted to clarify some things that occurred, and to make sure everybody remains in the best light possible. And so you all can just move forward. And so that's what I'm doing. I apologize for it taking longer than I anticipated. You all have a good day.
Thank you, Your Honor.
Thank you.